candle never goes out. Thank you, Mr. Speaker.
Steve Chadwick, the Honourable.
Well, I do want to take a slightly longer call because I think that member summed it up really, where he said that the Select Committee will consider this at great depth. But I do want to say that I'm proud to be part of a party that opposes this bill. I think this bill is simply dreadful. And I do just want to say too that I'm sure in Cabinet there have been vociferous debates about the great reformer of the legal and justice sector, Simon Power, who leaves, who until this bill and another one now languishing well down on the order paper, tended to get most of the reform agenda in law probably pretty well on button. But this bill we are really opposed to in this side of the House. And the reason why is it does inhibit access to justice and then creates an incredible potential for a substantial miscarriage of justice. And I know that the Attorney-General, who's very focused on proper access to law and due process, is probably very disheartened by this bill slipping in before the election, because he knows with a great criminal mind that lawyers around the country are saying enough of the great crusader and reformist in the legal justice. He's gone too far. He's gone too far with this bill, and it will impose substantial miscarriages of justice, and I'm really worried about that. Legal justice must not be denied those that are going through the court process, and I think this bill, even calling it the Sustainability Amendment Bill, is absolutely a crock. This is about capping access to justice, capping access to legal aid because of the cost implications for this government. It's not about sustainable funding. If it was about sustainable funding, it would have put a focus on the front end about those who go before the courts need debt management and how to actually manage their finances rather than capping their access to justice. I think one of the aspects in this bill that I feel most incensed about is about the means test that will be modified in the cases of offences that are not punishable by a maximum imprisonment term of 3 years. The Minister's indicated that this threshold will apply to those earning $22,000. Wow. Have those people earning $22,000, are they really going to be the bar for which we say above that level you can no longer have access to legal aid? Well, that's going to rule out so many people in the communities in which I live and work who find that through that access to legal aid they are encouraged to pursue their right to a robust justice appraisal of their case. And it is ridiculous to say that this will encourage legal aid applicants to consider whether they wish to proceed with legal litigation. For goodness sake, people earning $22,000 want to prove that they're not guilty. They cannot afford to engage a lawyer, so they go first to the community law centre. They go there first saying, what do? I've got a charge. I can't defend myself. I don't have the means to defend myself and speak for myself, though many do. I must have legal aid to help me. And to put that bar at $22,000 for a single adult is offensive, and for $51,000 for an adult with 2 dependents is absolutely outrageous. It is talking about affordability, and I understand really what National is saying, that people should do more for less. Legal aid is a nice to have, not a right to have, justice to be seen to be done. And to say that there could be a user pays element in terms of justice provision is offensive. This is as offensive as user pays was in the last decade that National brought in for the health system. Now they're doing a user pays philosophy for access to justice, and we find that on this side of the House absolutely offensive. I also want to say that the cut to legal costs by significantly expanding the public defender service at the cost to independent lawyers is a concern and has pressed a button right around the country. When we go around meeting lawyers, this is offensive to trained professional lawyers not rorting the system. They can see that the public defender service is a way of saving money, and already we've got the example that when that service was reviewed in Wales and England, it showed that this service actually costs the taxpayer more. So when are the national government going to look at what are effective justice measures, what are cost-effective justice measures? It's about paying for experienced lawyers who know how to work the system for their clients so that justice can be seen to be done, and that's usually the most experienced lawyers in the country, not those junior lawyers learning through legal aid. I find this bill absolutely offensive. Family court lawyers are going to find it offensive, and I think that just the introduction of this 12 weeks before an election to hope that we just slip it in on the order paper, get it off to a select committee so that we can go out there and say we, the national government, are doing great things about reforming the criminal justice process in New Zealand is an embarrassment. It's an embarrassment of riches for us in opposition to now go around the legal fraternity to say, have a look at this bill, see what they're proposing now. They're already offended. They're already offended by the Criminal Procedure Reform and Modernisation Bill, which I see as another bill of the great reformist Simon Power that slipped down to 18 on the order paper. Why is it on 18? Because National can't get the numbers to get that bill through the House, because they haven't got the support of the Maori Party, ACT and the Greens nor Labour, and they know it. And they've lost on this one and they'll lose on this one. This is another offensive bill. It's not a little bill. It's actually got huge implications to access to justice principles in this country that we in Labour hold dear, and we will be making sure through our networks of lawyers around the country that they know the provisions in this bill as are proposed. And as Mr Quinn said, yes, it'll go to Select Committee, and I think Government's going to be astonished at the reasonable and outraged response that they're going to get on this bill. Thank you, Mr Speaker.
The question is that the motion be agreed to. Those of that opinion will say aye. Contrary, no. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National?
57 votes in favour.
New Zealand Labour?
22 votes opposed.
Green Party?
9 votes opposed.
ACT New Zealand?
5 votes in favour.
Māori Party?
4 votes opposed.
Progressive?
1 vote opposed.
United Future?
1 vote opposed.
Mana? Honourable Chris Carter?
1 vote opposed.
Any other votes?
The ayes are 63, the noes are 57. The question is agreed to.
Legal Assistance Sustainability Amendment Bill, first reading.
Honourable David Carter.
I move that the Legal Assistance Sustainability Amendment Bill be considered by the Justice and Electoral Committee.
Question is the motion be agreed to. Those of that opinion will say aye. Contrary, no. The ayes